Welcome to Notable Approvals. I'm attorney Amanda Shaffer. I'm very excited to talk about our case today. It's another what I'd call a marathon case because of how long it went on. And we may have a notable approvals first. Our client may be joining us towards the end, but first we want to talk about all the facts involved because it's quite a complicated case. Before I get to that, a quick reminder, don't forget to like us, follow us on Facebook, YouTube, and LinkedIn, or Instagram, wherever you're watching. And if you find this video helpful or know someone who may, click that share button so that we can spread the hopefully useful information out there. So today's case is about a client who is a native and citizen of the Ivory Coast, or Côte d'Ivoire. He first, we'll talk about his entry, but we know it when he first entered, but the hows we'll get to. He first entered the US in 1992. And he applied for asylum. Like I said, I'll get to how he entered because that's part of why this became such a case that has gone on for almost 3 decades, over 2.5 decades. He applied for asylum in 1993. And in 1997, he had his asylum interview and was referred to court. In court, he withdrew his I-589, or his asylum application, and was granted voluntary departure. Voluntary departure means, and it's not available to everybody, it's a discretionary thing that basically if you have no way to stay in the US legally and you're a person of good moral character, no significant criminal history, you're telling the judge, look, I'm just going to go home myself. You don't have to force me out of the country. You know, you get, usually depending on the situation, you get about 3-4 months to leave the country. And if you don't leave the country within that time period, then your voluntary departure turns into an order of removal. And we always caution clients, don't take voluntary departure unless you're actually planning to leave, because it's a lot harder to reopen cases that if you ever do get relief from removal that had a voluntary departure order turned into a removal order versus just a removal order. And the reason is because you said under oath to the court, look, I'm going to leave the country, and then you didn't. So you have a little knock against you for that. So anyways, this was back in 1998, but he never left. Around that time, we didn't even know on the application when to put that he had gotten married to his first wife. He couldn't find the marriage certificate. He married a US citizen, and she filed a I-130 marriage petition for him. And my notes are blocked here. There's a long case. I had to take some notes. And it was approved. It was the marriage petition that was filed in 1999. He ended up divorcing her in 2010, but and he never ended up going past the marriage petition approval. So in the immigration case, he still had the order of removal. In 2012, he married another US citizen, and she's from Mali, and she's now a naturalized US citizen, and they had three kids together. So that I-130 was filed, that marriage petition, in 2013, and that was approved in 2015. After it was approved, they filed a motion to reopen his removal proceedings, and that was actually granted in 2015. I say actually, because again, he had a voluntary departure order turn into a removal order, and those in general are harder to get reopened. But he got reopened based on the approved I-130 so that he could get his green card. In 2016, now if you've listened to any of my notable approvals before, I've talked about people getting green cards in front of the immigration judge, and I've talked about people getting green cards with USCIS. In 2016, that was when Obama was still president, and they were terminating cases left and right. And the judge in that case terminated his removal proceedings. And that was based on the fact that he said that, even though they had said he didn't enter with inspection, he had no proof of his entry, he said, I did enter with inspection. I used somebody else's passport and visa, and I presented it at the airport and they let me in, which is different than just crossing the border illegally. And it also meant, well, I guess the reason being that USCIS could have jurisdiction, but the USCIS doesn't have jurisdiction if you enter without inspection. So the judge doesn't have jurisdiction if you entered without inspection. So I don't know if that's the reason why the judge did it. We weren't the lawyers back then. Regardless, case terminated. So they file the green card application as well around that time, and it goes back to USCIS. And what they say on their green card application is that he entered in 1992 using someone else's passport and visa. He had a copy of the passport and the entry stamp, but he didn't have a copy of the visa or the I-94 anymore. And he submitted all of that. So in 2017, they got a request for evidence because they wanted proof of his lawful entry. They didn't believe that he entered with someone else's passport and visa. And they ended up denying it. Now, what they tried to show, he did explain it, but in response to the RFA, because we did order his FOIA, or Freedom of Information Act file, which is when you can get your entire immigration file, and we reviewed it all, and he did try to provide proof that he actually used it, but it's 1992. Some of the documents might not exist anymore, like a plane ticket, for example. So they denied it. And when we did finally get the FOIA file, we saw that he actually was admitted with a C1 visa, which they had thought it was a B1 visa. It doesn't make a huge difference for this purpose, but it was interesting to see that it would make a difference if he didn't have the 245I, which I will get to in a little. So what we also realized when we were going through this file is at the immigration interview, I think at more than one immigration interview and on the forms that he signed, he had admitted to fraud. He admitted to using someone else's documents to enter the country. But USCIS said, we don't believe you used someone else's documents, you entered illegally. So we were kind of in a bind. Now what do? He's no longer in removal proceedings. They tried to provide proof of that he did actually enter the country, and this has serious implications because if you have it's a difference between a 601 waiver and a 601A waiver. So a waiver for fraud or misrepresentation versus a waiver for being in the country illegally. The biggest difference, for all intents and purposes, is that if you enter the country illegally, even if you're the spouse of a U.S. citizen, you can't get your green card until in the U.S. You have to file the waiver. It gets approved. It's the same standard of the extreme hardship. And then you have to leave the U.S. and do consular processing and have an interview abroad. And a lot of people are very understandably, worried about doing that. So in general, people prefer to have the fraud and misrepresentation waiver since it's the same type of waiver versus the illegal entry. The problem is sometimes proving it was actually you. So in 2019, again, this was before we were his attorney, he refiled. This time he filed the green card application along with the 601 waiver based on fraud. So not based on entering without inspection, based on the fraud, the document fraud. Hi, Tanya. Thank you for joining us today. So where was I, Tanya? You distracted me, but that's okay. So he explained in the waiver process, along with everything else, that he had this copy of the passport, and then he even had witness statements. The person who picked him up from the airport, I think someone who flew with him. There may have been the person who brought him to the airport. And he also filed a Form I-102, which is a replacement for your visa. I mean, your I-94. It's a I-94 replacement. And he told them that too, but he didn't have it in time to respond to the RFE. And the 2019 application, the green card and the waiver, were both denied, again, because there was no proof of entry. And because there was no proof of entry is why the I-485 got denied. The I-601 got denied because he filed, that would then be the wrong waiver he filed. They didn't even have to look at it, basically, because he should have filed the 601A in that case. So then they filed a motion to reopen the I-485, the green card application, saying that they have alternative proof of his entry. They had, again, the passport bio page, this time specific facts. So like the airline he took, the flight number he took, the date he took it. They were able to find all this information, specific facts about it, again, the witness statements, and that they filed to replace the I-94. And that would not have been a motion to reopen I would have filed, to be honest. If I was his lawyer back then, we would have said, you know, if they don't believe you now, they're not going to believe you with these witness statements. You know, let's see what the situation is, because sometimes you order the FOIA file and you actually get what you need, like the proof of entry, and then you don't have the issue. You'd be surprised at what they know about you, even if you think, oh, I used an alias, that may very well be in your file, especially because he had the guy's name and passport number. So 2020, I called it an appeal, but it's essentially an appeal, but it's called a motion to reopen. It's denied, they come to us. So once we get the file from immigration, we're going through it, and this was a really, really difficult one. And it was difficult for us to decide what the best path was, because on the one hand, we're like, you admitted to fraud, so you might need a fraud waiver. But on the other hand, they don't have proof of your entry, so you might also need a 601A waiver. But as we were going through the file, we realized something that no one, for some reason, realized until they came to us, which was that he was 245I eligible. And I will explain what 245I eligible is. I've had a couple of cases that I've talked about in notable approvals, and I always say we get excited about these cases because they're rare and they actually, you know, really can save people who have been in this country for a long time and didn't think that they had this relief from or path to a green card. So, Nikki, I see your question. You're asking if I'm answering questions, you have a question. I'm only answering questions specific to what I'm talking about. Otherwise, my contact information is scrolling across the bottom of the screen. Encourage you to reach out. I'm happy to talk to you. But if you have a question about what I'm talking about, then I'm happy to answer that right now. So to be 245I eligible, you have to be the beneficiary of a qualified immigrant petition. Qualified means that it's on its face approvable, doesn't even have to necessarily have been approved, of either a Form I-130, which is the alien relative petition, or a Form I-140, which is a immigrant worker petition, or a labor certification. So it's the step before the I-140. And it had to have been filed on or before April 30th, 2001, and you need to have been physically present in the U.S. on December 21st, 2000. And there is also, it also applies if you are the principal beneficiary of one of those qualifying immigrant petitions that were filed between January 5th, 1998 and April 30th, 2000. And the first one that I mentioned, April 30th, if you filed it before April 30th, 2001, then one of those don't need the physical presence requirement. I can't remember off the top of my head. regardless, he needed the physical presence requirement because when it was filed. You also have to have a properly filed green card application, a supplement A application. There's an extra $1,000 filing fee. You have to be physically present in the US, so you can't, when you're filing for your green card, so you can't do this outside the country. You have to have a visa immediately available, so an immediate relative, or your visa number is now available. And you have to be admissible or eligible for a waiver of inadmissibility. And you have to, of course, warrant a favorable exercise of discretion, meaning the positive factors outweigh the negative. Nikki, I see your question. It is not, unfortunately, directly related to what I am talking about, but I will be happy to answer it afterwards. If you shoot me an email or give us a call, we can talk about it, because that she's asking about automatic citizenship for her child. That's actually not an easy question to answer, but I can answer that. So reach out to us and we'll see what we can do. So 245I eligibility, the main thing you really have to know, I kind of ran through a long list of things. The main thing you need to know is that you have to have had a qualified or an approvable on its face petition that was filed for you basically on or before April 30th, 2001, and you have to have been physically present in the US December 21st, 2000. And it doesn't have to be, obviously I mentioned this client has a new wife now. It doesn't have to be the same person or the same company that filed for you. It just has to have been filed by somebody, and it doesn't even have to have been approved. It has to have been filed properly, and it has to be bona fide. So it has to be like a real filing, not just to have, filed for some relief from immigration. So we realized when we were going through his FOIA file that he was the principal beneficiary of an immigrant petition that was filed between January 15th, 98 and April 30th, 2001. And that he was, of course, he hadn't left the US since he entered, so he was here December 21st, 2000. So once we realized this, we said, well, he finally received his I-94 that he used when he entered with the other person's passport. And he did admit to the fraud in multiple times before USCIS. So, and even the denial notice said that or the RFE said you said that you entered with someone else's papers, but prove it. So we went back and forth regarding, is 245I going to work? Are they going to deny it, saying you didn't enter the country without inspection? Now are they going to say that, or even if you did enter without inspection, you admitted to fraud, now you need a fraud waiver? Juan said that those 245I cases are definitely something else. You're very correct, Juan. And USCIS, because these cases are so old and it's pretty rare these days, they get confused when they have these cases. And it will show in this case as well what their confusion was. So we went back and forth about this. But fortunately, the 245I doesn't really matter how you entered. So whether it was fraud or not, even though they could technically try to, if they really wanted to push us, say that you needed a waiver, but the law said even if you entered with fraud, if you had the 245I should work for you. So we also realized, look, they didn't believe you before that you entered with this person's document. Yes, you got the I-94. You filed an application to get it, which we wouldn't have recommended doing because you have to file it as, I can't file it as Amanda. I have to file it as the other person. So it's not ideal. And you don't know if they're going to locate it. And not only that, they had such actually good evidence about his entry that really wasn't believed already. So we didn't see the I-94 being of any type of help. So we said, I think it's better to file it as an entry without inspection and do the 245I. We have the I-130 approval notice. So he didn't just have it filed, it was approved in 99. And then the harder part then is how do you prove physical presence on a specific date from 2000? Well, there are lots of different ways. And fortunately, in this case, he was working and was receiving pay stubs. So he had a pay stub. We submitted a couple pay stubs, one from December 15th, 2000 to like the pay period to December 21st, 2000. And December 21st is the day. And then the next paycheck, which was December 22nd, 2000 until December 28th, 2000. So we showed he was working during that full time period, couldn't show that specific day. He got paid for that time period. That's great evidence. Sometimes we've submitted leases, credit card, or bank accounts, so things that are there, school records if you're a child. But again, we're talking, generally speaking, it's been now 20 plus years since it's not generally speaking, since December 2000, it's been 21 and a half years. So that evidence might not exist. Now you can always resort to secondary types of evidence like affidavits from people around at the time, but there is much less of a guarantee that it will be approved. Those pay stubs were solid evidence, so we were really excited. So we finally filed the green card application for him with the supplement A, which is for the 245I, with all the evidence in 2001. And we ended up getting 2 requests for evidence. And I'll get to that in 1 second. And I will say another interesting fact about this case, and why I really want to talk about it, is if you look at the green card application, after you fill in all of your information, I don't know which page, I want to say page 8, maybe 9, wherever it starts, maybe 10, wherever it starts are the security questions. And I've never answered yes more than I have in this case than any other case. In general, you don't want to be answering yes to any questions. So these are the questions about arrest, illegal entry, fraud, removal proceedings, gambling, prostitution, killing people, terrorism, all those types of questions. So in general, the more yeses you have, the harder it's probably going to be for you to get approved. And that's always a concern. So, and actually it all goes to good moral character. Now, one of the yeses was about arrests, and he had 7, but they were all traffic related. So basically, this is very common in the immigrant community until more recently, because, and well, in some states even so now, that until recently, like in New York, for example, if you did not have lawful immigration status, you couldn't get a driver's license. So a lot of our clients have these same charges, and usually they're just dismissed or you pay a fine. But it goes to good moral character. We had a green card case flat out denied for a client who was arrested 8 times and never actually had to plead to a crime, was never convicted. They all ended up being dismissed. And basically, we explain, like, look, maybe he hung out the wrong people, maybe he was in the wrong place at the wrong time, or maybe there's racism going on here. And they didn't accept our argument, and they didn't accept the appeal. And there was really nothing we could do. They said, we don't believe he could possibly be arrested 8 times without doing anything wrong. I honestly believe that client, but it's not up to me, unfortunately. So we also had to say yes to him working without authorization, which is accepted. It's not an issue if you're an immediate relative. So he was, as a spouse of U.S. citizen. We had to say yes to violating his non-immigrant status, even though USCIS was saying he didn't have a non-immigrant, because you never want to say no when it should be a yes, because then it looks like you're trying to hide something. So you had to be cautious, and we had to be as cautious as possible. And it took us a while to decide how we were going to answer some of these questions, because it gets tricky. Had he not admitted to the fraud and just said he entered without inspection, then he then there's no proof he violated non-immigrant status. But we're always as honest as we possibly can. We obviously knew that, and we didn't want to have problems. We just wanted to be honest about everything, and that was the goal here, and it worked. So we said yes. He entered with someone else's visa, and he didn't leave the country when his authorized period of stay expired. We also had to say yes to that he's ever been in deportation proceedings. We also had to say yes to he was granted voluntary departure but didn't leave the country. We also had to say yes to applying for relief from removal. And we also had to say yes to fraud and misrepresentation. So those are a lot of yeses. And that meant the back page of the form where you explain everything, I think I had 3 back pages for this case. And, all of those things do go to good moral character, and they're all concerning. But, to be honest, this client, I've known him and his wife for a long time, and they're really great people. I believe they're watching, and they know they're free to join if they choose to do so, to talk about their experience. But, it didn't feel fair for him to get denied based on these things, because a lot of these things, even though there were a lot of yeses, they weren't that bad. Even the arrests were traffic infractions, So first we get a request for evidence saying that we didn't submit his birth certificate. I sigh because he's driving me nuts, because of course we submitted his birth certificate with the certified translation. But I've gone on rants about this before. If you ever get a request for evidence from USCIS, even if you gave them exactly what they're asking for, you still have to respond, and you still want to give them. This is why you make a copy of anything you submit. We scan everything into the computer before we mail it. So you still have to send it to them. So we sent it back to them. We sent it to them again. Great. Then in 2022, they had their interview. And this was an interesting one too, because this got scheduled when I had been scheduled to be out of the country. And fortunately with COVID, we are now allowed to do these interviews by phone, but I was actually in another country doing it, which was a first for me. And I was very scared about not having Wi-Fi. We got there early to make sure that I wouldn't have a problem, left early for the trip to make sure. My husband has international phone or whatever as well. So that, we had our ways if the Wi-Fi didn't work. But I had to make sure of that, or I would never leave my clients hanging, of course. So I called in, or I get called. I don't call in. They go in. We thought they were going to be separated. Oh no, we didn't. No, their I-130 was approved. I lied. I'm sorry about that. So we start the interview, and the officer tells me they're in the process of converting this file to electronic, and she has an incomplete file in front of her. And I was just like, all right. So now we have, usually that means we have to reschedule. She decided that she wanted to go forward with the interview. So I said, okay, we want this case to be over, to be approved and everything. And the thing is that what she was missing was the 245I stuff. So she says, first thing she kind of says is and this is why they hired me to be in the interview with them, to make sure I can explain it. And I've said before that I tell clients all the time, sometimes I recommend that you have us there, and sometimes I tell you, it's not if you don't want to pay for us to come, don't worry, you'll be fine. This was a case where, it was a mutual consent where we both, my clients and I both said I should be there. So I explained to the officer, we submitted the supplement A, which was, I think it was, I always make a supplement as an exhibit. I said we have submitted the supplement A as an exhibit whatever. I had it in front of me, and we submitted the approved petition, we submitted the proof of his physical presence. And I said, because the petition was filed on or before August 30th, 2001, and he was physically present in the country on December 21st, 2000, that means he is 245I eligible and does not need proof of his entry. So she says, okay, well, I don't see it here, but I'll take your word for it. If I need anything, I'll let you know. And then she proceeded to ask my client, the rest of the security questions. And we were supposed to have a translator for the interview. Now, my client speaks English, but not great English. He speaks French. And the officer didn't know how to, this was not even that, this was, what year are we in, 2022? Yeah, this wasn't even that long ago. But she still could not figure out how to put me on the phone and put the translator on the phone, which the translator should have been there in person. At least pre-COVID, French translators were, you could always grab one. So she asked me if they would agree to proceed without the translator. Now, I had practiced with my client answering these questions because he had to, this is the type where you have to really prep your client properly, because if you don't want them saying yes when they should say no, or no when they're saying yes, and then you want them to be able to explain it. Because a lot of this was very technical. He might not understand what voluntary departure was. He might not have understood it when he took it back in '99. I don't know. But he's going to be asked about it, and he has to know that he took it and didn't leave and what that meant. So we did actually do a practice session just on the yeses in the security portion, which ended up being incredibly helpful because she did ask him all of those. I mean, those were the ones she focused on. So the interview went really well, except obviously we couldn't get a decision because she didn't have the whole file. So I forgot, maybe a month later or 2 months later, the USCIS officer calls me. And this is very rare. I've only had a few ever call me. And she said to me, she can't find the 245I evidence that I submitted. And I was like, I don't know what to tell you. I scanned it before I send it. I can send it again. And she's like, well, let me send you another request for evidence so you can submit it. So in March 2022, I get a request for evidence asking for proof of the 245I requirements. We put in exactly what we put in before, and to be on the safe side, we even submitted additional evidence. So, and this is another good piece of evidence to show physical presence. Our client had been going to the same mosque since, before 1999, since he entered the country. So the imam at the mosque knew him the entire time he was here, and was able to write a letter attesting that, he regularly has attended mosques since before and after that December 21st date. So I don't think we needed the extra evidence, but I always say the more the merrier. It never hurts. I knew she told me she couldn't find it, but like maybe she found it and didn't think it was sufficient. The USCIS officer is not my friend. So, we're cordial. I'm always really nice to them, but I don't take them always for their word. I have to protect my clients and be on the safe side. So I resubmitted that with the extra evidence. And then finally, my client calls me last week, and she's like, there was a status change online, and it says that like it was approved or that the card was being created. And I was like, well, we haven't received any documentation yet, so I never like to get excited until we receive the actual documentation. But we finally did this week. I told her I'm not talking about the case. I'm not doing anything until we get it. We're not popping bottles. I was like pulled off all excitement until we get the actual approval notice, because the online system has had errors before, and that's not legally binding. So this case was finally approved after all of that. And actually, it only took a year from when we filed the green card application, which with 2 RFEs and a half lost file is actually amazing, honestly. I mean, I've come on here and I've said that we got a case approved in 9 months, and I'm ecstatic. But anything less than a year is amazing, and that's with no issues. Whenever there's issues, it extends it out. Obviously, for both requests for evidence, we had the evidence already. I mean, except for that one letter that they got right away, so we responded right away. You usually have, I think, like 63 days to respond. So it can be delayed because you take a while to respond, but we always respond as soon as possible. So I'm extremely happy for these clients. After living in this country since 1992 without lawful status, after not seeing his family for 30 years, he finally has a green card. He can go travel. Everything. His removal proceedings have been terminated, so we don't have to worry about that. And he's now been married more than 2 years, so he received a 10-year green card, and in 2 years and 9 months he'll be ready to file for his U.S. citizenship. That was a lot. To recap, if you have been here for a very long time and you're having trouble proving your entry, whether you lost your own paperwork, you came with someone else's paperwork, or entered the country illegally, and you now have an immediate relative or a visa number available, or not a job. Generally speaking, it has to be an immediate relative. Let's just say that to make things simple. And you have an approved petition, it is worth getting your file from your FOIA file, your immigration file, and having an experienced immigration attorney review it before you start filing things left and right. Because if we didn't get his FOIA file, we would never have known about the old petition. Like, we ask people all the time, we go through, we have like a checklist where to see, like, whenever there's a question about which way we're going to do something. And we knew that this case was complicated from the beginning when they came in and they talked about how they were trying to prove his entry, and they couldn't. But he didn't even think to tell us about that. We said, "Has anything been filed for you before?" And he may have said that he thinks so. He was married before, but like he doesn't remember what happened to it. He didn't have the documentation. Some people will say, did someone file for you before? And they may say no, just because they don't have the documentation and don't realize how important it is. So if it wasn't for ordering the file, we wouldn't have seen it. And then just because we saw that, again, the complication in the case didn't end there. We had to then figure out, well, how's USCIS going to view all of this? Are they going to try to claim now there's fraud, even though we have 245I? Are we going to need the waiver anyway? And we discussed with them, look, we might, if this gets denied because now we need a fraud waiver, then now we need a fraud waiver. But the 245I should work anyway, because of the entry. They're saying, plain and clear, you didn't enter the country with inspection and admission, therefore you're inadmissible. So we were able to resolve that. So for all of you who've stuck with me through this marathon notable approval, I appreciate it. It is a really interesting and complicated case, and I'm so happy for my clients that this is finally resolved and that we were able to do this. Again, 245I cases we love because usually people don't realize they're eligible for it when they come into us. And again, the I-130 didn't have to have been approved necessarily. So if you or anyone thinks that they may be eligible, or questioning, you have an issue of fraud on entry, our contact information is scrolling across the bottom of our screen. Please do not hesitate to reach out. These are the type of cases that we love to be able to figure something out that other people weren't able to. We're pretty good at that. Nikki, if you're still watching, feel free to reach out to me. I could talk to you about automatic citizenship as well, and any other immigration questions or matters that you have, feel free to reach out. Don't forget to like us and follow us on Facebook, YouTube, Instagram, wherever you are watching from. And if you found this to be helpful or know someone who, hey, maybe they might be 245 eligible, I should have them watch this, go ahead, click that share button so that they can. And again, we're here for you, and hopefully you are, and I can talk about your case in the future as well. So that is all today for notable approvals. Thank you for watching and have a great day.